My name is Haley Upton. Thank you so much for joining us for the Navigating Subchapter V Bankruptcy webinar. This topic will cover, like we said, the new or semi-new Subchapter V Bankruptcy. I'm Haley Upton, the Marketing Coordinator of Events and Proposals here at Ward & Smith, and I'm going to be your moderator this afternoon. If you have any questions with video or sound quality during the presentation, please reach out via the Zoom chat feature. Our speakers are happy to take questions during this webinar. If you have a question, please type it into the Q&A box on your toolbar, and it'll be addressed either during the presentation or at the conclusion of the presentation. But please know that we are monitoring those throughout. Today we have Lance Martin and Paul Fanning. And Lance, I'm going to go ahead and turn it over to you.
Thank you, Haley, and welcome everybody to this webinar on Subchapter V Bankruptcy. My name is Lance Martin. I practice bankruptcy and creditors' rights here at Ward & Smith and have done so for almost 25 years. And I'm joined by my colleague, Paul Fanning, who's a board certified specialist in bankruptcy and also practices in creditors' rights. And he too has been doing this at Ward & Smith for about 25 years. This wouldn't be possible without the wonderful assistance of Haley Upton. So thank you, Haley. We want to talk about Subchapter V today. And so sort of first principles is we're talking about Chapter 11 of bankruptcy, and Subchapter V is a subchapter of Chapter 11. And most of you, I'm sure, are aware that Chapter 11 is the bankruptcy process by which a business entity, your borrower, uses the bankruptcy code to restructure and reorganize their debt over a period of time. They typically remain in operation of the business while they do so. Traditional Chapter 11 can be complex, it can be time consuming, and it can be expensive, particularly for small business owners. And so Subchapter V was added to the bankruptcy code under the Small Business Reorganization Act as an attempt to make the bankruptcy process more accessible to small businesses. The goal was to give small businesses a more simplified and streamlined process to reorganize their debts. And so the core provisions of the Small Business Reorganization Act or Subchapter V were to sort of give the debtor sort of more leverage to negotiate and confirm a reorganization plan, give them more control or a greater ability to retain control over their business, and then to sort of reduce the procedural hurdles, the roadblocks, the burden, the costs that come with a traditional Chapter 11 that's more suited to a larger business than a small operation. You talk about timing being everything. Subchapter V came into effect in February of 2020, so it was not drafted and authorized and voted on by Congress with the pandemic in mind, but it took effect right before the pandemic hit the United States. And it became sort of indispensable to small businesses during the pandemic. So we are approaching the 3-year anniversary of Subchapter V. Our experience in North Carolina is that it is very popular. The overwhelming majority of Chapter 11 cases that have been filed in the last 3 years in the 3 districts in North Carolina have been filed under Subchapter V. I think we're close to like 115 cases filed in the last 3 years. Historically low numbers for Chapter 11 period, but of those, the vast majority, I think 75% or more, are being filed under Subchapter V. Just a couple of quick stats. Under a traditional Chapter 11 case, 3 out of 4 fail. So there's about a 25% success rate. And the typical Chapter 11 case lasts over a year, usually around 16 to 18 months. By contrast,
Lance, you're muted.
Sorry about that. I think I was saying that under traditional Chapter 11, 3 out of 4 cases fail, and they typically run for a year to 18 months. The data on Subchapter 5 for the first year that it took effect was over 50% success rate and average length of less than 6 months. So we will go into the details of why that is and what distinguishes Subchapter 5 from a traditional Chapter 11. But we will start by talking about who's eligible to file Subchapter 5, and I will turn it over to Paul.
Yes, and I also want to say thank you to everybody who has joined. I was able to review the list of attendees before we got started. I see a lot of friends, a lot of clients, a lot of very knowledgeable special asset professionals, and I'm really pleased to see such an honored group. So thank you for attending. Yeah, starting with the eligibility, who can file this Subchapter 5. This subchapter is available for an entity. We're talking corporation, limited liability company, limited partnership, sole proprietorship, or an individual. The kicker is that the debtor must be engaged in commercial activity. There's also a threshold of debt to qualify for a Subchapter 5, and that is $7.5 million. It's interesting to note that when the bill was first passed, it was about a little over $2.5 million. It was quickly raised during the pandemic to 7.5 and has since been raised, and it's staying at that threshold. When we talk about the debt limit, we're talking about non-contingent, liquidated, secured, and unsecured debts that are counted in that number. You have to be under that number to qualify. And at least half of those debts have to come from business activity. And in that number, you don't count debts that are owed to affiliates of the debtor or insiders of the debtor. You just don't count those when coming up with that number. Individuals can use Subchapter 5 to reorganize guarantee debt, even if their company is out of business and has been shut down. As long as the debt was incurred in the business, they can use Subchapter 5 to shed that liability or reorganize it. You can't be a single asset real estate operation and qualify for Subchapter 5. So single asset, think one piece of property, the only asset of the company, no operations, those don't qualify for Subchapter 5. Nonprofits are eligible, but reliance on speculative future donations is really a high hurdle to cross over. And where we're talking about sole proprietorships, we're basically talking about an individual. That's an individual case. Next thing I want to talk about is the requirements for filing a Subchapter 5. When a debtor files the case, they have to opt into this subchapter. They have to check the box They have to check that they're a small business debtor, but they also have to opt into the Subchapter V. If they don't, it will proceed as a traditional Chapter 11 case. And in a little bit, I'm going to talk about the differences and the benefits, but in terms of the filing requirements, with the petition, the debtor has to file a bunch of financials. They have to file their most recently prepared balance sheet, last statement of operations, most recent cash flow statements, and the most recently filed tax returns. If they don't have any of these, they have to explain why they don't have it, and that's under penalty of perjury. For individuals, they're not going to have those financials, but they will have tax returns and they have to file those. And they can be required to file bank statements if needed in place of some of those financials. Notably, if an involuntary case is filed against a debtor, they can elect to proceed under Subchapter V as long as they qualify and meet the requirements that we talked about earlier. Debtor under Subchapter V, as all debtors, are required to maintain insurance, which is customary to the debtor's industry. And throughout the case, there are ongoing financial reporting obligations. We're going to talk about the fact that Subchapter V does not require a disclosure statement. Most all of you know exactly what that is. It's not required in a Subchapter V, but in its place, there are ongoing financial reporting obligations. Those would include reporting about profitability, the earnings and losses during a defined period of time, reasonable estimates of cash receipts and disbursements, actual to projected reconciliation, proof of compliance with any tax payments, tax filings, government filings. And Subchapter V comes with a bunch of official forms that are prepared with these requirements in mind. Noting that we're dealing with a new subchapter of Chapter 11 that's conceived to be consensual. Lance, why don't you talk about how this process is supposed to work and a little bit about the role of a Subchapter V trustee?
Yeah, so one of the interesting aspects of Subchapter V is that it throws this new player into the mix. So in every case, unlike a traditional Chapter 11, you've got this character, Subchapter V trustee, and he or she is appointed by the bankruptcy administrator on day one of the case. And I'm sorry, we just keep getting some glitching in Asheville over here with the weather outside. Their role is to facilitate a consensual plan of reorganization. They are usually bankruptcy practitioners in the district where the case is filed. There's a panel. I actually serve on the panel for the Western District of North Carolina, and I've served as a Subchapter V trustee in a couple of cases now. And when we get together, we all kind of scratch our heads, even 3 years later, as to exactly what we're supposed to be doing. So depending on your case, you might get a very activist trustee, where you will feel like you have been forced into mediation from day one of the case. And I'm sure all of you as experienced special assets officers have been to court mandated mediation and have gone through that process, and you may have strong feelings about it one way or another. But in Subchapter V, you have some trustees who are very activist, who are hell-bent on getting a consensual plan confirmed. And so they will be pestering you and your counsel throughout the life of the case as to what can the debtor do or what can you do to get this plan confirmed. Other trustees I have noticed are much more passive, and they just kind of sit back and let the case play out. But so our role, the role of the trustee is to facilitate a consensual plan of reorganization. So essentially try to mediate a resolution that doesn't involve plenty of protracted litigation. They can serve as an ally for you if you are not getting the information you need to make a decision on a plan from the debtor or the debtor's lawyer. The trustee can be a go-getter and go get you what you need. I think there was an expectation when Subchapter 5 was passed that the trustees would bring some sort of financial acumen and expertise to the table so that they could evaluate the plan alongside the creditors to determine its feasibility. In practice, at least in the Western District, it's almost all lawyers. Some of us have more or less experience than others at reviewing and analyzing balance sheets. But I would say, like, I wouldn't count on sort of financial wizardry coming from the trustee. You will need to do your own internal analysis. And then sort of one practice pointer we would give to you is that remember, when you get to confirmation or the status conference before confirmation, the judge is going to turn to the trustee and ask him to report on what's going on in the case and what he or she is hearing from the other creditors in the case. So you want to cooperate with the trustee. You don't want to blow him or her off lest he or she report that to the court, which is going to put you in a bad light when you start making your arguments for or against confirmation. The trustee is paid by the debtor. So the debtor's plan has to provide for means of payment for the trustee. And there's one other important aspect to the Subchapter 5 trustee. They have this general role, which I've explained to you, but Subchapter 5 allows for the trustee to be endowed with enhanced powers. And so if you have a case where you suspect fraud, mismanagement, gross incompetence, just some real problems going on that need and merit further investigation, you can move the court to give the trustee more powers to essentially subpoena documents, take depositions, do a thorough investigation, and report to the court and the parties. And this can be a very powerful weapon to wield, either as leverage with the debtor that you're going to do this, or to actually do it, and the results can be used to get a case maybe dismissed or converted to a Chapter 7 liquidation. And the beautiful thing for you as a creditor is that you don't have to pay for it. This is something that the debtor essentially has to pay for, or the trustee is going to have to do it essentially pro bono. So that's in a nutshell what you need to know about this new character of the Subchapter 5 trustee. I'll now turn it back over to Paul to talk about benefits of Subchapter 5 and kind of what you can expect to see versus what you won't see that you would see in a traditional Chapter 11.
Yeah, thanks, Lance. Good points there. That traditional Chapter 11, in at least in my experience, and I'm sure it's shared with this group, is, you get the filing in, it's going to be a long slog. It's going to be expensive. We're going to have to go to a bunch of hearings. We have to file claims. We want to get the stay lifted. Maybe we don't. We got to chase the debtor for financials all day long. I'll explain a little bit about the differences with the traditional Chapter 11. First of all, we've talked about the Sub 5 trustee. Those are appointed by, in North Carolina, the bankruptcy administrator. In other jurisdictions, it would be the U.S. trustee, but they're appointing a Sub 5 trustee in all these cases. The debtor may, the bankruptcy court may order that the debtor be removed from possession for cause. What do we mean by that? As Lance was talking about, fraud, dishonesty, incompetence, gross mismanagement of the affairs of the debtor. And it's important that it could be either before or after the bankruptcy filing. Another circumstance under which the bankruptcy court could order a debtor be removed is if the debtor's not performing their obligations under a confirmed plan. If they're not doing what they agreed to do and what the court ordered them to do in an order confirming a plan, the bankruptcy court can remove the debtor. And in its place, the Subchapter V trustee operates the debtor. Another difference in this new Subchapter 5 is there's no creditors committee. A lot of the cases that we see in North Carolina, there is no creditors committee because in North Carolina, at least, they send out a survey, and if they don't get enough interest in serving on a creditors committee, there just isn't one. So sometimes you don't see it, but in the big cases, there is a creditors committee. And in Subchapter 5, there is no creditors committee unless the court appoints one for cause. There's also no disclosure statement. Think about in Chapter 11's traditionally, the disclosure statement is your prospectus. It is the debtor's projection of what's going to happen and the reasons why. It's something that you rely on in order to determine whether to vote in favor or against the plan. And we often see fights over the adequacy of a disclosure statement. In Subchapter 5, no more. Now, remember all of the financial reporting that we were talking about earlier that is required of the debtor. That takes the place of the disclosure statement. In addition, in a Sub 5 case, the plan that the debtor files must include a brief history of operations, a liquidation analysis, and projections which would demonstrate the ability of the debtor to make the proposed plan payments. And that's the real meat of a disclosure statement anyway. Notably, in a Subchapter 5, the debtor has the exclusive right to file a plan. In traditional Chapter 11, the debtor has the exclusive right only for a finite period of time, after which other parties can file their own competing plan. In a Subchapter 5, the debtor has to file a plan within 90 days after the order for relief. And the bankruptcy court can extend that deadline, but only under circumstances for which the debtor cannot be held accountable. What does that mean? Well, it means that the debtor's delay is not going to be enough to get them an extension of that deadline. If it's something under the control of the debtor, then they better file that plan in 90 days or they risk dismissal of the case. If it's not their fault and it's something for which the debtor cannot justly be held accountable, then the court can extend that deadline. Interestingly, this Subchapter 5 bankruptcy allows for the plan to modify mortgage security interest in a debtor's principal residence. If the money was loaned not primarily to purchase the property, and the money was loaned in connection with the business. If those two elements are present, then it's possible for a Subchapter V debtor in its plan to modify that debt. A lot of people don't think about that. Also, in a Subchapter V, there's no absolute priority rule. Well, what's an absolute priority rule? Absolute priority rule basically says that the owners of the business can't retain their ownership interest unless all other creditors are paid in full. In a traditional Chapter 11 case, they either have to pay everybody else in full to retain that ownership, or they provide new value to the case to retain that ownership. There's no absolute priority rule in a Subchapter V, and as a result, existing equity holders are more likely to retain their equity interests, and that's attractive to debtors looking to file bankruptcy. Acceptance of a plan by an impaired class of creditors is not required for a cram down of a plan in Subchapter V. In a cram down plan, the debtor must use all of its disposable income or contribute property having a value of at least all of its disposable income to make plan payments to creditors over a period of 3 to 5 years. As long as they can do that and they prove to the court that it's fair and equitable and it doesn't discriminate, then they can cram a plan down. They don't have to have an affirmative vote. Everybody can vote against the plan and it still gets confirmed. Another important difference is administrative expenses in a Subchapter V plan can be paid over the life of the plan. They don't have to be paid up front as they do in a traditional Chapter 11 case. That's really important if you're a creditor that happens to have a big administrative claim, maybe it's post-petition rent or some other reason. If you've got a big administrative claim, you can hold up confirmation in a traditional Chapter 11 plan, but not in a Sub V. They can pay that over the life of the plan. Importantly, the discharge. If the plan is objected to but is still confirmed, discharge of debts doesn't apply until after all the payments are made, and that's an important distinction. And there are no quarterly fees paid by the debtor in a Subchapter V case. Lance, this is meant to be more efficient. How efficient are we?
Yeah, so the words that come to mind are warp speed, like in Star Trek. So cases filed, Chapter 11 cases filed, and the Subchapter V election box is ticked. And then within 30 to 45 days after that, the debtor has to file status report with the court. Here's what's going on. Here's the major creditors that we've spoken with and their position. Here's where we are in terms of preparing our plan of reorganization. That report is filed, and then within 60 days of the filing date, there's a status conference. And the judge is there, the debtor's there, his counsel, the bankruptcy administrator, Subchapter V trustee, and any creditors who want to participate. It's not a hearing where anything's decided, but it's a status conference where the judge has the opportunity to ask questions of the parties, and the debtor gets to apprise everybody of what's going on. The plan of reorganization is due within 90 days of the filing. And that's a pretty hard deadline. The court is only supposed to grant extensions for matters that are outside of the debtor's control. So it's a pretty high standard. Contrast that with a traditional small business Chapter 11 plan where the debtor has 6 months before they have to file a plan. And if they want an extension for another 90 days, they basically just have to file a motion. It's a very low hurdle to clear. Once the plan is filed, the court's going to set a confirmation hearing, and typically he or she is going to set it within 30 days of the plan filing date. So you were talking about 4 months from the date the case is filed, in which you need to be in court with your counsel arguing if you're going to oppose the confirmation plan. Within 4 months, you could be arguing it in front of the judge. And that's what the statute requires. In practice, what we are seeing is that cases are moving even faster than that. And by way of example, over the last several months, we represented a creditor. The petition was filed on November 22nd. So right before Thanksgiving, they filed the petition. They didn't even wait for the status conference to file their plan. They filed their plan on December 8th. So about 2.5 weeks later, they filed their plan, and the confirmation hearing was scheduled for January 10th. So less than 60 days after plan filing, we had a confirmation hearing, and this plan was extremely problematic for our client. So we had to kick it into gear pretty quickly. And if you take nothing else away from this webinar, I would encourage you that when a petition comes across your desk, don't put it in a stack to get to it later. This is something you want to address immediately. For example, if you think valuation is going to be an issue, you're secured by real estate, for instance, and you're due for a new appraisal on real property, you need to put that into motion immediately, because if it's going to take your appraiser 45 days to get out to the property and then another couple of weeks to give you an appraisal report, that may be too long, and you're going to need counsel to go to court and try to seek an extension on the creditor's side. So you have to move quickly. I was involved in a case as Subchapter V Trustee. It was an individual case, financial advisor. There appeared to be a considerable amount of potential fraud pre-bankruptcy. This creditor had a very large claim, and they wanted to conduct discovery. They wanted to depose the debtor and look at some bank records. And I told them, this was their first case. I told them, I said, sounds like a reasonable request. You need to get started right away. They didn't. They waited until about a week to 10 days before the confirmation hearing to send out discovery and file a motion to examine the debtor. And then we got in the court of the confirmation hearing, and they were asking for more time, and the judge wouldn't give it to them. And then the judge said, this case has been pending for 90 days. Why didn't you start this process, 75 days ago? And you would have had it completed by now. So the lesson there and the takeaway for all of you is that in a traditional Chapter 11, you have time to sort of get your bearings. In Subchapter 5, you've got to get active and decide what your strategy is going to be, essentially from day one. And with that, I will kick it back over to Paul to talk about confirmation.
Thanks, Lance. And Lance, check out some of these questions that are popping up, and you can reply to them while I'm talking. The confirmation. So we talked a little bit about it earlier. In a subchapter 5, a debtor can confirm a plan even without acceptance by the creditors if the plan does not discriminate unfairly and is fair and equitable. The most powerful aspects are that the plan just contributes all projected disposable income for at least 3 and no more than 5 years, much like a Chapter 13 individual reorganization. It's notable that projected disposable income is everything after expenses to maintain and support the debtor or dependents and expenditures necessary for business operations. In order to confirm a plan, the court has to find that the debtor can make the payments under the plan, or there's a reasonable likelihood the debtor can make the payments, and the plan contains appropriate remedies to protect the creditors if they don't make the payments. Practice pointer here. This is an opportunity for an active creditor to really look out for themselves, and it's important to do so. During the negotiation process, you're negotiating claim treatment, how your claim is going to be treated under the plan. It's much like a negotiation over a forbearance agreement. What are the terms of that forbearance agreement? We carefully craft stock or shelf loan documents to detail events of default and remedies on an event of default. Those go out the window in a bankruptcy unless they are either preserved or detailed in the plan. So I would encourage you as a practice pointer to think about during that process, making sure that you have appropriate protections, appropriate remedies in the event of default of a plan. Creditors, just like in a traditional Chapter 11 plan, they must receive at least as much as they would get under a liquidation Chapter 7 case. So we talked a little bit about the consensual. There are 2 types: a consensual plan and a non-consensual or a contested plan. And we talked a little bit about if there's a consensual plan, debtor gets a discharge on confirmation up front. That's a pretty powerful tool for the debtor. If it's a contested plan scenario, then there's no discharge until all plan payments have been completed. There's also notably involvement of a Chapter 5, Subchapter 5 trustee. If it's a consensual plan and the plan gets confirmed, typically the Subchapter 5 trustee goes away. His job is done. If it's contested, there are provisions in Subchapter 5 that keep the trustee in place to make the disbursements called for under the plan and to make sure that the debtor's doing what they're supposed to do under the plan. So sometimes it's important to contest the plan so that you get these extra protective provisions in the plan. Speaking of contesting, Lance, you want to talk about fights worth having?
I do. And before we get to that, there was a question in the chat about, what have you seen as far as the quality of financial statements and disclosures in Subchapter 5 versus traditional Chapter 11? In my experience, they are not as robust. With a traditional Chapter 11, any case with real meat on the bone, the debtor has typically employed an accountant, a certified restructuring officer, some sort of consultant to work with them to prepare projections that we as counsel for creditors often argue about, but they are coming from a professional place and professionally prepared. By contrast, in Subchapter 5, it's a little looser. And one of the problems with the case moving so fast is that you don't get a lot of real-time actual information on the company. So in terms of with a traditional Chapter 11, you're in the case for a year, you're getting monthly operating reports. You're seeing how the debtor is operating for a long time in bankruptcy. You don't really get that in Subchapter 5. You might get one monthly operating report before you're at a confirmation hearing. And this it kind of bleeds into what I would call the spirit of Subchapter 5. And the spirit of Subchapter 5 is that it's rough justice. You know, it's going to be a fast process. We're not going to spend too much money. There's a preference for compromise. So at least in the cases we've been involved in and seen, there's not a tremendous amount of litigation. We're not seeing dueling experts fighting over valuation of assets. We're not seeing experts put on the stand to fight over feasibility of business projections. But that's kind of a segue into our last topic, which is fights worth having. I don't think Subchapter 5 is just a situation where, oh, it's a Subchapter 5 case, we just have to roll over, we get what we get, and we don't pitch a fit. There are issues that merit a fight if you're being mistreated by the debtor. One is eligibility, which Paul talked about at the beginning, the $7.5 million threshold. Looking carefully at the debtor's obligations and doing the math and scrutinizing it is important because if they're over the limit, then filing a motion to dismiss them or convert them to a traditional Chapter 7 can be a powerful piece of leverage for you, because many of these debtors, they don't want to be in traditional Chapter 11, then they would sooner have their case dismissed or I guess they don't really want it converted, but they would sooner have it dismissed than go into traditional Chapter 11. So eligibility is one. The other, as Paul talked about, the big sword that they were given under the Act is the ability to use projected disposable income, pay that for 3 years, and then if that's 10 cents on the dollar and they make all their payments, then they're free, they're discharged from their unsecured debt at that point. There's at least one bankruptcy court judge who issued an opinion in the last month who required actual disposable income. And he wanted the plan to require sort of quarterly reporting and essentially a true up based on what the actual income available for the payment of creditors would be. So in a situation where there may be some uncertainty or high variability as to what the future income of the debtor is going to be, I think this is an avenue worth pursuing with the debtor in negotiating the terms of the plan. And then if you can't, and you're at a contested hearing, pushing for this with the court. The other one, and this is one you really have to watch out for, we see it all the time. So a company can file Subchapter 5, an individual can file Subchapter 5, but they have to do it separately. They can't combine and file a single bankruptcy petition. And what we are seeing is that what debtors' attorneys will do is they will file their Subchapter 5 case for the entity. and the entity's borrowed money from you, and then you've also obtained a personal guarantee from the owner or the members. And those, and what the debtor's attorneys will do is that they'll put in the plan that upon confirmation of the debtor's plan of reorganization, the company's, the guarantee obligations are released as well. They'll ask for a release of the guarantee obligations, and or they will ask that creditors are enjoined from pursuing the guarantee obligations during the life of the plan. This is strongly disfavored in the law. The Fourth Circuit, which is the big court that the bankruptcy courts have to follow, have said time and again that these types of provisions should only be allowed in extremely rare circumstances. But the debtor's attorney have heard that language and they've interpreted it as, so you're saying there's a chance. And so in every case, they are putting this language in their plans, and you've got to get it stricken. And the courts will, as long as you catch it and object to it. And some of the more scrupulous debtors attorneys will kind of throw their hands up sheepishly and say, yeah, you caught me. I will take it out of the plan before we go to confirmation. But the last thing you want to do is have a plan come through uncontested and get confirmed that not only, that would eliminate your right to pursue your secondary obligations like guarantor debts. I mean, if you're dealing with an SBA loan, this could be catastrophic for you when you went to collect on a potential SBA guarantee. The other fight worth having, I would point out, is sort of corporate bad behavior, like any sort of pre-bankruptcy fraud, willful and malicious misconduct. We see this more in commercial litigation than with borrower-lender relationships. But if you've got some fraud involving lender obligations, these things can't be discharged under Subchapter V. There was some thought, and some courts in other states allow corporate debtors to discharge this type of debt in under Subchapter V. Our big court, the Fourth Circuit, has said no, businesses can't. If they're going to, it goes back to the absolute priority rule and what's fair and equitable for the parties. So if you've got something like that, remember, if they're going to try to get that discharged in their plan, it's a fight worth having. If they won't voluntarily remove it, the court will for you. So I think we are getting towards the end. I did want to, before I kick it back over to Paul, I saw one question in the chat asked, please address if there's any change in considering sale of an account receivable as a true sale and granting relief from state fairly quickly. On that second part, stay relief fairly quickly, this gets back to kind of the rough justice aspect of Subchapter V. I think if you go in the court immediately and say, there's a filing and you file a motion for stay relief and you say, the nature of our relationship is that I bought those receivables, they're not property of the state, they're mine. Give me stay relief to collect them. I think that my experience is the court's going to pump the brakes on that. I don't think the court's going to take up that motion. I think the court's going to say, well, this sounds like you're blowing up any chance that the debtor has to reorganize. If the debtor's saying, no, don't grant stay relief because I need, I need this, the receivables or whatever, and we think they're property of the estate, that this wasn't a true sale, this is a disguised lending relationship. I think what the court's going to say is, I'm going to continue your motion and we'll take it up at the time of confirmation. Okay. And you go back and do your mediation with the Subchapter V trustee and talk to the debtor and see if this can't be worked out. And if it can't be worked out and you, I don't confirm a plan of reorganization on the confirmation date, then I will then take up your motion for stay relief at that time. So I think the odds of getting quick stay relief on a debtor asset that the debtor is saying they need to reorganize, I think the odds of you getting stay relief early on are.
Yeah, Lance, I agree with you completely. If I could just add on there, you know, when you're arguing over the bundle of sticks and who owns it, you know, that's more properly brought in an adversary proceeding, in a lawsuit. And that lawsuit, the process of that lawsuit stretches far beyond the timetable that we're talking here. So I think that if the court says, hey, there's a dispute about who owns this stuff, file an adversary proceeding. In the meantime, we're going to go to confirmation, and you may end up with a plan that's bifurcated, that has an alternative relief for you. So it really is most times, I think, in your best interest to work through that issue as quickly as you can. If you can get a consensual plan together, great. If not, you know, you may have bitten off more than you bargained for.
Yeah. One question in the chat was, why do you think some feel Subchapter V is not good for a bank trying to collect via workout? I think one reason is that I think debtors think they can do better in Subchapter V without the attendant costs. So is Subchapter V really less expensive than traditional Chapter 11? Yes, I think so. You know, they don't have to pay quarterly trustee BA fees like in a traditional Chapter 11. That can be a few $1,000s a month that they don't have to pay. They don't have to do the disclosure statement, like Paul said, which is a lot of work and time consuming for the attorneys. And no disclosure statement means no disclosure statement fight. It's the rare Chapter 11 where you don't have multiple iterations of the disclosure statement and multiple hearings fighting over those iterations. All that goes away. There's likely no experts. They don't have to pay for experts. And then resolution in 6 months or less versus over a year means less legal spend, fewer pleadings to draft, fewer hearings to attend. So I think they look at, well, if I can make an honest, relatively honest, reasonable projection of what my projected disposable income is, and I can get this through cram down, then I might be able to get out of this, my relationships with my unsecured creditors for pennies on the dollar. And that, you know, that may be better for a debtor who maybe has, you know, several creditors than, you know, trying to do a workout or a forbearance agreement with a single creditor who may be trying to get more from them. So I think that is why you may see this as a challenge in a workout situation.
You know, I may be able to answer Vince's first question through kind of the wrap up on creditor considerations. Vince asked, please address how this will impact DIP financing for asset-based lenders. You know, one thing to keep in mind is there are a lot of things that don't change in a Subchapter V. You're still going to have cash collateral issues that pop up immediately when the case is filed. You're still going to have to negotiate adequate protection. You're still going to have the same fights over the automatic stay. The provisions are exactly the same in both types of cases, traditional and Subchapter V. Those don't change. And as far as DIP financing goes, that is a fight that's not going to change, but it's going to be in a quicker process. So I think that's the only difference that I can think of there.
That's right. Yeah, my first case as a Subchapter V trustee, the debtor sought DIP financing in the case. Some of the creditors supported it because they were going to get taken out, but they were going to be replaced by the DIP lender who was charging like a typical DIP interest rate of like 18-21%, something like that. I opposed it as Subchapter V trustee on behalf of the unsecured creditor class because I felt it was a bad deal for them. There was sort of a narrow window of equity that was in the debtor's assets that I thought would be eaten up by the additional interest. The court ended up denying the DIP financing loan. But Paul's right. We don't see too much DIP lending at this level because of the Subchapter V cases are smaller, so there's not as much of a demand for DIP financing, but the same rules would apply as to a traditional Chapter 11. There's another question, I think it disappeared, but I saw it earlier. They're talking about if a Subchapter V is given enhanced powers, could they retain a forensic accountant to assist them? It's a great question. So it gets to cost. I think if the trustee went to the court and the parties and said, look, the type of financial digging that needs to be done is, beyond the scope of my expertise, and I need to bring in somebody who can do this work, and it's important for the case. I think the judges would approve that type of thing, but I don't think that expense would be borne by the debtor. I think that's a situation where the creditor who is advocating for that would have to front the expenses of the appraisal. We have already had cases where Subchapter V trustees have tried to retain their own counsel to assist them in the case, and the courts have struck that down as inconsistent with, again, the spirit of the statute, additional expense, additional burden and procedure, another person that needs to be dealt with. So they want the trustees to do plenty of things in the case, but they also want the case to remain as inexpensive as possible for all the parties.
Yeah, a couple of just creditor things to keep in mind. The cram down provisions regarding secured creditors remains the same. You're still entitled to the same type of cram down provisions that you would see in a traditional Chapter 11. This is a sophisticated group and they know what a Section 1111B election means. That is still available in a Subchapter V or 5 case, and so that's an important tool that can be used. And the Subchapter V trustee, we talked about facilitating these discussions. These are primarily panel trustees that are appointed by the U.S. trustee or the bankruptcy administrator. They vary in experience, but one thing is for sure, they wouldn't be on the panel unless the court was comfortable with them. So you want to make them your friend. That's really all I've got left for my part. Lance, do you want to close us out, or will Haley jump in and do that?
Well, I just wanted to reiterate what Paul said earlier, which is thank you for taking time to join us. It's a shame we can't do it in person and socialize and share a meal together, but we're not prognosticators on what the future holds in terms of the economy, but I do feel confident that if you do get 10 new Chapter 11s in the next year, that 7 or more will be Subchapter V. If I'm wrong, the next time you're in Asheville, let me know and I will buy your lunch. But yeah, thank you for taking time, and let's do it again real soon. I'll turn it over to Haley.
I was muted. Thanks, Lance and Paul. You guys are always so engaging on this, and thank you to everyone that logged on today. We had a wonderful turnout and just really great engagement. Following this webinar, you'll be sent an email with a recording of the session, as well as these slides for you to reference. Like they said, I really appreciate, Warden Smith really appreciates you taking the time to join us today, and hope that you learned something very, very valuable. Please stay tuned for emails to come later this year. I know that the creditors' rights team really loves to do webinars, and I'm sure we have more on the horizon. So that's going to conclude today's webinar, and I hope everyone has a really great rest of their day. Thank you.